Hi folks, and welcome back to Innovation and IP. This is video 2 in the video series on commercialization part 2, and in this video series we are looking at the business planning stuff that you engage in before you actually go ahead and negotiate your licensing deal. It's going to make you a bucket load of money. So in video 1 we had a look at an overview, and we also had a look at the commercialization process, and now we get to jump into the business structures that you might want to use for your commercialization endeavor. As I said in the first video, you really do need to have a fairly good overview in your mind of the commercialization process, the things that happen at the various stages, the business decisions that you'll need to make in the various stages, and therefore the funding that's available, and all of that, as you can see if you've already watched video 1, will tell on the kind of vehicle that you choose to adopt to actually carry your commercialization venture off, hopefully into a skyrocketing success. So here we need to look at firstly the sole trader. I like this little graphic because he certainly does look like he's rather lonely and sole trading on his own there in that bus. Obviously, a sole trader just means that you get out there and you start trading under your own name and for your own purposes. So you are simply getting out there and mixing it with everybody else. There's no setup costs for that in terms of business structuring. You don't have to pay anyone to use your own name. You do need to register a business name, obviously. But it's very, very simple. You just get out there and, as Nike would say, you do it. Pros and cons here, mostly cons. You do, obviously, as a pro, have 100% of the ownership and control. So that's got to be said. If you are the kind of person that has to have absolute control, this is great. You do get all the profits for sure. Problem with that is that if you're already being taxed at the top marginal rate, then unfortunately you're going to have all of your income from the venture being also taxable at the top marginal rate. So it all will flow personally to you as the taxpayer responsible for that income. It also means that you bear 100% of the risk of the venture. So in the good times, you'll be making a lot of money. Yes, sure, you'll be paying a lot of tax also, but you have 100% of the risk. So when things go wrong, the assets that you've built up and the income that you might have been squirreling away for a rainy day is all on the line. It's all at risk. And creditors can directly access that if and when you ever need to go bankrupt. So real problems with this kind of structure, if you want to call it a structure. The other thing I'm sure that you're thinking here is, hey, hang on a minute, AJ, look at those various different phases of the commercialization process. Isn't it going to be hard to snag some investors that are willing to open their wallets and throw some cash at you? Yes, it's very, very difficult, and I would say almost nigh on impossible. You're going to have to look at some form of legal structuring, really, if you want to do anything more than just have a little hobby on the side here. So that's your sole trader option. Really not terribly appealing. Then you need to think about, well, do we go into something like a company structure? This is by far and away the most common structure that you will find for tech startups. There are two kinds of company, as you will all know. I'm sure you could almost sing along with me, you know, watch the little bouncing music note and follow the words. There's two kinds of company. There is a proprietary company and there is a public company format. And the proprietary company is the easiest to set up and maintain. Really super easy peasy. Only takes about 15 minutes online, and what I want to do is actually run through this stuff with you so you can see just how easy it is. It's not scary at all. It really only gets complex when, as I say on the slide, you're looking at converting from a proprietary limited company to a large public company. So you're going to float on the stock exchange and allow the public to trade in your company's shares. Why would you want a company? Very, very simple. You pay a flat 30% tax on the income, but most importantly, the company itself is a separate legal person, a separate legal entity from all of the founding directors of the company. Therefore, as I said, the company is taxed as a separate entity. They'll get the 30%, it will get the 30% tax rate, and it will also have the risk and liability quarantined within that company itself. So personally, the directors that sit behind the company don't have their own personal home and assets, car, money, savings put on the line when they are getting out there and starting up a new venture. So that limitation of liability is probably the main reason why you would set up a company structure, and so you call it a proprietary limited company. As I said, super duper easy to set up a little proprietary limited company. Firstly, you swing on over to the ASIC website, and I have given you the website address there. Have a look at that. Simple, simple. Steps 1 through step 7, and all of a sudden, bingo bango, you have yourself a company structure. Let's have a little look at what's involved. Firstly, there's a few decisions that have to be made. You need to choose the name, obviously, and if you're savvy, you might wish to trademark the name. You will need to decide how the company will operate. And here I'm thinking specifically about replaceable rules. There is a set of replaceable rules that look like a company constitution. That's meant to be a constitution on the right hand side of the screen there, that we the people, that's the closest graphic I could get to a constitution. But on the left hand side you'll see the index from the corporation's legislation there for you. Section 141 is the table of replaceable rules there, and all of these little provisions are designed to just basically save people the time and effort of actually having to draw up a constitution. Look, very well intentioned little set of rules there. However, despite the fact that just relying on the replaceable rules is pretty quick and easy and cheap, as I say on the slide, there are very real benefits to actually getting a constitution, a company constitution, drafted up. Why is that? Because you can provide for things like tailoring your own provisions on governance, how governance of the company is actually going to work, what classes of shares that you might wish to actually split up in the company. You might have Class A shares with all of the voting rights, most of the voting rights. You might have Class B with almost no voting rights, but just the ability to participate in dividends. You can really split it up, however you want. You can set your own details on calling and holding meetings that are convenient for your particular circumstances. You can easily change them. You can't change the legislation. And also the replaceable rules just aren't even applicable anyway to sole director and sole shareholder companies. So you need to choose your name, and you need to think about the replaceable rules or a constitution. You can rely on a hybrid of the replaceable rules and constitution. That can get a bit messy, as you can imagine. So they're your initial decisions that you need to make. Then you need to, I like that graphic, all directors are little angels, aren't they? You need to think about duties that will be undertaken as an office holder of the company. There are very, very serious obligations that rest upon office holders, particularly directors. There's a couple of administrative things, but the ones that I'm really thinking of that pack a punch are the director's duties. So you have to look at mundane things like, keeping the company details up to date with ASIC, paying your renewal fees for your company registration. But the director's duties are the ones really that you need to be cognizant of when you're taking on a company structure. So you can't just run fast and loose and operate, very close to the wind with your honesty and good faith dealings with others. You need to, steer a fairly reputable path once you look at taking on a company structure. So Section 180 is your section of for care and diligence. So all of your directors have to exercise proper care and diligence, good faith in your dealings. You can't misuse your position. You can't misuse company information for your own benefit. All of those things I'm sure that you're aware of already. If not, go and have a look at the legislation so that you can properly advise your clients. You can find out far, far, far more detail on all of this stuff if you have done your corporations law unit. And if you don't plan on doing a corporations law unit, as I said, I probably would recommend having a look at the legislation so you're aware of what duties will apply to all directors. There's also some very good, very simple outlines on the ASIC website. Next, you are going to have to get some consents, and you're going to have a director, has to be over 18, the secretary also over 18. Secretary is not like a person who does the typing, by the way. Secretary is the person who deals with the administrative tasks mostly. And you'll also have to have members, so every company has to have at least one member. What is that? That is a shareholder. So minimum is one director, one secretary. If you've got a public company, which, as I said, this is the bigger, badder version of a proprietary limited company, you need to have at least two directors that ordinarily reside in Australia. You need to set up a register to record details of shareholders, and you need to get the consent of your registered office owner. So a lot of proprietary limited companies can't afford their own premises to start off with, so they will either get their lawyers or their accountants to actually put down their address as the company's registered office address. You have to get their consent to do so, so you need to make sure that that's all squared away. You don't have to send the consents into ASIC, but you certainly do need to have the consents on your company records. You need to keep them. Okay, so the next thing is, how exciting. You go ahead and you hit the blue button. You get to step 6. You've got your consents. You know about all your duties. You've sorted out your constitution and your name and so forth. Got all the information arranged. You hit that blue button. And you'll see, I've given you a couple of screenshots there. It says, do you want to register a company? Register your company. You click the blue button. You click Australian company and company name. And then it runs through all the information that we've just talked about that you'll need to actually put into your application form. And then you hit start applying. It's as easy as that. You go ahead, you pay your incorporation fees, and bingo bango, as I said, you have a proprietary limited company. Really good little vehicle for getting your venture up and running, and certainly one that the investors will probably want to see. So that is the company. Then we have the also-rans. Okay, partnership. Well, yes, you can structure things as a partnership, but this tends to be extraordinarily difficult in a lot of different ways. The biggest disadvantage really here is the magnitude of risk that you have. So you're not only responsible for all of the partnership's risk yourself personally, but you're liable for acts that all of the other partners do as well. So while it does allow some tax offsetting, that is, if the partnership makes a loss, you can deduct that loss from your own personal income as a partner. However, all of your own personal assets are at risk. There's none of that protection that you get from having a limited liability company at your disposal. The profits do flow to the partners personally. Again, much like a sole trader, this can be a big disadvantage if you're already paying tax at the top marginal rate. Any extra income that you're going to get into the partnership through your commercialisation activities are going to be taxed at the top marginal rate. Probably the worst aspect of doing any commercialisation venture by way of a partnership is that the partners will jointly own the intellectual property that comes out of the venture. And joint ownership of intellectual property is just not something that you anytime want to contemplate without at least a full appreciation of the nightmare that you're getting yourself into. I talk about this in the study guide, but just to run you over it very briefly, in terms of patents, if what's going to come out of the venture together with the other partners is patentable inventions, widgets, then the position is this. The partners are all entitled to an equal undivided share of the patent, which means that they can all exploit the patent themselves on their own account without actually letting the other partners know or accounting to the other partners for their share of profits. So you can exploit it on your own, you can keep all the profits on your own. Think about that though. If you actually go ahead and exploit and the partnership wants to grant some kind of exclusive license to somebody else for a nice price, well, they're not going to be able to do so if you or a number of other partners have gone ahead and are exploiting the IP yourselves, because you can't guarantee exclusivity, can you? So there's a lot of hairs on this particular dog. Also, co-owners can't license third parties or assign without consent of all the others. So whilst you can actually go ahead and exploit yourself, you can't allow others to do it for you. And that means then that if the partnership has hit some relational troubles and you're finding it difficult to communicate, or there's some animosity there, it's going to be quite difficult to get the consent of everybody to actually go ahead and enter a licensing deal or an assignment and actually go ahead and make some money out of this thing. In terms of partnerships, where the university is one of the partners, they often won't be in the position of being able to exploit, as they are able to do under the legislation. They often won't be in the position to exploit the invention on their own, but they also can't obviously license without the industry partner's consent if it's an industry partner that they're actually aligned with. And so there's no incentive for the industry partner to consent to the university going ahead and doing deals on its own, is there really? So you can end up with stalemates and some fairly serious arguments. Co-ownership really is a position of last resort. You can, if you are in a partnership, you can sue without the consent of the other partners if there has been patent infringement. Obviously, this can also lead to arguments because the rest of the partnership might not wish to sue and indeed may wish to enter a lucrative settlement arrangement or license the infringer. So you can see there's some problems there. In terms of copyright, under the Copyright Act, you can't do anything as a partner without consent of all of the other partners. Look, as the University of WA has come out and said, joint ownership really is just a way of putting off discussions about the appropriate commercialisation path and just leaves difficulties for a later date. You're going to have squabbles. If you're going to have squabbles, you might as well have squabbles at the very beginning of your commercialisation venture. Get everything hashed out, squared away, everyone's on the same page, rather than leaving it until later. You find you're in a partnership, you've got joint ownership, and it really can be a bit of a mess. So Not to put too fine a point on it, that's just my own personal view there, having seen some things that go wrong. So the other option here, and I know that the text talks about this one, is the trust. The trust is a very complex arrangement. If you've done your equity and trusts unit, you'll know what I mean. If you are not a law student and you're not going to take the equity and trusts unit, well, congratulations to you, because as I said, it's a fairly difficult unit. But the trust, it's quite difficult to set up and maintain, expensive to set up and maintain. You're going to have to get a lot of legal advice and usually tax and accounting advice as well. The problem here with a trust arrangement is that because the trustee owns the legal title to the property that comes out of this venture, including things like intellectual property, if the trustee can't actually pay their creditors, or if the trustee, even worse, breaches their fiduciary duties to the beneficiaries of the trust assets, I think it says, can be put at risk. It should say the trust assets can be put at risk. So all of a sudden you think you have a trust that has some nice tasty assets there, and they can be stripped away, unfortunately. So that is the trust. I will leave you to explore the trust arrangements that can be implemented for commercialisation purposes in the text. Go ahead, paddle around in that and see what you think. All in all, really, the company structure is, as I said at the beginning, far and away the most common and the most tried and true, probably the cheapest and most effective structure in order to get your startup up and away. So that is business structuring. The last thing I just wanted to cover off in this video series was the choice of the commercialisation vehicle. And what do I mean by commercialisation vehicle? I mean the form that your deal is going to take place in. So either an assignment or a license. They're your two main options. There are a myriad of permutations of each of those, but for our purposes here, the big ticket messages to take away are that an assignment, when you think about assignments, you normally think of getting completely rid of whatever it is that you're proposing to sell. And that may be the case. Particularly with IP, you may dispose of all your right, title and interest in the IP, but an assignment can actually be partial. So you might note that the legislation allows copyright, trademarks, designs and patents to be partially assigned by way of geographic region. Copyrights and patents can be assigned by way of classes of act. Patents, you can make, you can sell, and you may wish to allow one person to make and one person to sell. You can assign part only of your interest if you are a registered owner or a design. You may, and also copyright, because the legislation says that you can split up your assignment in any way. Part only of goods or services. So this is particular to trademarks. The legislation says that you may assign your trademark for some of the goods in which the trademark has registration over, or some of the services. So if your trademark applies to t-shirts, merchandise, as well as cups and pins, you may wish to assign the trademark to one person to deal with the cups and pens and one person to deal with the t-shirts and merchandise. So patents you can also assign by way of, part of the goods. So if your patentable process, for example, can be equally applied to manufacturing sliced meat and sliced, something else, cheese, then you may wish to assign the patent rights to one person for that one application, making sliced meat, and the other person for the other application. So that is assignment. In relation to licensing, we will go into this in far more detail in a couple of video series' time. However, the big ticket items here for us to take away is that the license retains your ownership of the property that you are licensing out. All it really is a forbearance to sue. It just allows the other person to use the property that you're licensing in the way that you stipulate they are allowed to use that property. It actually conveys no proprietary interest whatsoever in the property itself. So if you think back to your property unit, you know, something like a lease also allows somebody to go ahead and use the property. The thing is, with a lease, you actually get a proprietary interest in the land that you are leasing, the property that you are leasing, unlike licenses. Okay, you get no proprietary interest whatsoever. You are just there on the licensor's good graces, so to speak. You can license under all of the different statutory regimes, no problem. Usually an exclusive licensee can file infringement proceedings. You might, depending on the legislation that you're suing under, need to join the registered owner of the IP, except for designs. An exclusive licensee of a design doesn't even have that right. They are looking at changing that right now as we speak. Non-exclusive licensees need to request the owner to sue. And you have a number of different licenses that you can grant. It might be a sole license. And a sole license grants somebody else the right to use the property, but it also retains a right in the owner of the property to also use the property that's being licensed out. So the owner can use it and the licensee can use it. A non-exclusive license simply allows just a whole bunch of people to use whatever property it is, and the exclusive license is very, very different to a sole license. An exclusive license means that the owner themselves even cannot exploit the property. The person that you're granting the license to has the exclusive right to do so. And there's a lot of misunderstanding around sole, non-exclusive and exclusive. Get those distinctions straight in your mind, and we will learn a lot more about licensing, as I said, in a couple of weeks' time. So that is the commercialisation vehicle, and that is the business planning stuff of our commercialisation part 2 topic. So, as I always say, if you have any queries or questions, don't hesitate to contact me via Teams, email, phone, send a carrier pigeon. But until then, I look forward to perhaps seeing you in a tutorial sometime soon. And until all of that, bye for now, guys.